reservations in favor of OBCs were solely on the grounds of caste, thereby violating the anti-discrimination clause found in Article 15 of the Constitution. It was further suggested that reservations in favor of already well-represented OBCs would not serve the stated objective empowering the weaker sections of the society. So, the paragraph that I was referring to is para 16. Which is at page 72. I'm sorry, stand corrected. Page 72. But the first part my friend read, therefore I will not repeat it. Paragraph 60. The first part my friend read. There is no doubt in our minds. I'm skipping that. Last line, your worship, see just last third line. The identification of backward classes for the purpose of reservation is an executive function. And as per mandate of Article 340, dedicated commissions need to be appointed to conduct a rigorous empirical inquiry into the nature and implications of it. This is what I was suggesting. I was emphasizing. The emphasis is on empirical inquiry, not on demographic inquiry.
That is also reiterated in that Krishnamurti.
This is Krishnamurti.
This is Krishnamurti.
This is Krishnamurti only I am reading. That is reiterated in the later judgment. Later judgment, your lordship will get a paragraph 16, page 93. Para 16, your lordship. At page 93. That is not read by my friend, therefore I am reading it. At page 93, paragraph 16. The argument of the respondent state that reservation in favor of OBCs must be linked to population is very wide and tenuous. That plea, if countenanced, will be in the teeth of the dictum of the constitutional bench of this court, where it has been noted and rejected. Now that is rejected, my lord. The court has expounded about distinction in the matter of reservation in favor of SCs and STs on the one hand, which is constitutional reservation linked to population, unlike the case of OBC, which is statutory dispensation. Therefore, the latter reservation for OBCs must be proportionate in the context of nature and implications of backwardness. In any case, is permissive only to the extent it does not exceed the aggregate of 50% of the total seats in the local bodies reserved for SCs, STs, OBCs taken together. This one. Then my friend also had read the interim orders which your lordships will get at page 191. That is order.
One 191.
191. But there is a continuation order for this also. This is 191 is order number 1. Rahul Kumar Wagh. There is order number 4 where the Supreme Court.
Necessary hazard of professional. Yes, please.
At page 191, your lordship will get cited order number 1. That is because the Supreme Court has passed series of orders. In the same case, subsequently order number 4 was passed.
Yes.
Your lordship will see paragraph 15 is enough for me. Other things may not be necessary. The last page, my lord.
Para 15.
Para 15, my lord. Be that as it may, any election notified by Madhya Pradesh Election Commission after 4/3/21 ought to strictly comply with the triple test requirement indicated in the decision of the 3-judge bench of this court in relation to reservation of OBC category seats. Then not similarly, my friend had also cited at page 195. This is a subsequent order, continuation of this order.
So,
paragraph 3 at page 797.
Same thing being reiterated.
No, what they said is, in this case, what happened? Interim report was submitted. But after that, GO was issued, interim report was submitted. The Supreme Court said, lordship may see for a moment para 2. Why I am saying this is, in our case, even the report is absent. Report is not forthcoming till date. Then the report, there is a division by judgment of this solemn. In fact, this is not the first time that the government has attempted this.
It was attempted earlier also. I am also contending that this is contrary to the division bench judgment of this honorable court, wherein certain parameters were laid down. When similar attempt was made, that also I'll point out only, then I'll wind up, I'll not trouble the honor. Page 796, second page, para 2, your lordship will see. Third last line, for the report itself mentioned that same is being prepared in the absence of empirical study and research by the commission. Supreme Court had occasion to consider that report, and ultimately at paragraph 3, as a result, why, to what extent the Supreme Court has cautioned, para 3. As a result, it is not possible to permit any authority, much less the State Election Commission, to act upon recommendations made in the said report for the time being. We do not intend to dilate further. Then there's one division by judgment. This is contrary to the judgment of the Honorable Court, which is reported and which is also part of the booklet filed by my friend. Page 101, it begins, Lord. That is the matter of Nimaka Jairaj, 2012, 6 ALD 329, page 101 of this booklet. Your Lordship, see paragraph 58 at page 116. This was in respect of 2014-12 elections. Then paragraph 15, it is argued. Mary, yes, page 116, para 58. It is argued on behalf of the state that the reservation of 34% is being followed since 1994, and even during the elections held in the year 2006, the same percentage of reservation was adopted. Therefore, it is acceptable. But we are not inclined to accept this submission on behalf of the state, for the reason that in the state there is no empirical data and the reservation is based on unpublished data. This is important. The state government is required to conduct detailed investigation with regard to backwardness of the population, collect data. It's not percentage. That's what I'm saying. Demographic, there's much difference in saying that demographic and empirical. Collection data, invite objections from the general public, analyze the same, and then fix reservations in accordance with the empirical form. Now, all these ingredients are absent in this case. Therefore, clause 1 is also violated, is my submission. Then the conclusion is paragraph 61. What is to be done in the present by way of an interim arrangement? That is also set out in paragraph 61 at page 117. Then lastly, I would also submit that State Election Commission does has a role. But what they are not expected to be doing a postman job. They are part of the constitutional machinery. Now, wherever they find that there has been a constitutional infirmity and that the state is not acting in accordance with the required mandate under the constitution, as also the judgments of the Honorable Supreme Court in terms of Article 141, if there is any such violation, the State Election Commission is not required to just formulate whatever they recommend. But that is set out in this judgment of 2021 8 SCC 401. The relevant paragraphs, I'll just skip, I'll only give the numbers and leave it there. That they have followed the earlier judgment. Your Lordships will see in paragraph 30 at page 420. Then paragraph 82 at page 424. Your Lordship may for a moment have a look at page 8, para 82 at 424. They can't be simply issuing notification because the government wants it. In the aforesaid context, Your Lordship, para 82. This is an extract of the earlier judgment. Therefore, I don't want to. Para 25 starts. But at page 424, para 82. This is a part of the earlier judgment, which is at page 25. Para 25, I'm sorry. I don't want to trouble the Honorable Court by reading the whole judgment. Page 424, Your Lordship will see. Top page 24. Your Lordship gets 82. This is a part of the judgment, my Lord. This is not part of this judgment. In the aforesaid context, We do not appreciate the helplessness expressed by the SEC, the State Election Commission, which is supposed to be an authority independent of the government of Goa. The fortuitous circumstance that SEC is also the law secretary, government of Goa, is not sufficient circumstance to express helplessness in the wake of an unconstitutional and ultra-vires order by the Director of Municipal Administration Urban Development. According to us, it was the duty of the SEC to require the director to immediately rectify the impugned order and to provide for reservation of less than one-third of the seats in favor of women rather than rush and issue election schedule. That's all. I leave it to you. I am obliged to the.
May I please, my lord? My lord, we have filed this writ, which is item 1 in lunch motion, my lord. And this writ is in addition to the grounds that are there, and the challenge in this writ is not only for GOMS 9, but also the election notifications, my lord, which is why this stands on a different footing to some extent as opposed to the other writs, my lord. And therefore, I would just like to put before my lord certain arguments which have a lot of bearing on the matter and may invite my lord's interference and insofar as the interim relief for the staying of these notifications is concerned, my lord. I will take my lord to the notification before that GOMS from the perspective of the election notification, my lord. I would invite my lord's attention to that, my lord. My lord may kindly see the GOMS 9, my lord, which is on page, my lord may give me a moment, page 34.
Yes, sir.
My lord, the writ number is 30557, my lord.
Yes, yes.
My lord may kindly see the referenced subject caption matters that are there in this GO, my lord. It is GOMS 49 BC welfare dated 4/11/2024. Thereafter GOMS 18 planning department dated 10/10/2024. Thereafter GOMS 1 BC welfare dated 27/2/2025. In this GO, there is no mention anywhere of the Telangana Panchayat Act 2018. This GOMS 9 does not appear to have the intent in any manner affecting any of the provisions of the Telangana Panchayat Act. In fact, it is not even giving effect to any of the provisions. It is merely a GO which is in fact actually intended, it appears from a plain reading, to be a next step to the bill which has been passed. Therefore, my lord, this is in no manner related with the Telangana Panchayat Act, my lord. What has the Election Commission done thereafter, my lord? Election Commission on 27/9/2025, my lord. I will just hand over these notifications. They are not there in the writ, my lord. My lord may kindly see the notification that was notified by the SEC, my lord. This talks about an amendment by the GOMS 9 of the Telangana Panchayat Act, my lord. This is a wholly arbitrary and fundamentally legally incorrect position, my lord. There is no amendment, and in any event, judicially, legislatively, an amendment to an act cannot be done through, my lord, a GO. A GO which is purported to be under a bill, my lord, which has not even become an act. So now what is happening? There are two legislative pieces, one arguably not still an act, even assuming that it is a deemed act, my lord, even assuming that, there cannot be, the GOMS has to decide where it sits. Either it sits under the bill, which is the argument put forward by the other side is that it has become an act, or it sits under the Telangana Panchayat Act, my lord. As of now, it is very ambiguous where this GO goes. What does this notification say, my lord? For my lord's benefit, I will just read it out. I will just hand over the notification to the other side as well. In exercise of the powers conferred under section 9 and 17 of Telangana State Panchayat Raj Act 2018, keeping in view of amendment issued through GOMS 9. My lord, there is no capability of a GO to amend an act which has been passed by the legislature and thereafter has received the assent of the president, the governor. That is an act which can only be amended through a legislative action. Now, the legislative action which is referred to in the GOMS, my lord, GOMS 9 is in page 35, my lord, where it says after careful, therefore in this GOMS, my lord, what they have done is they have detailed the circumstances under which GOMS 9 came about. They have spoken about the bifurcation of the state, the formation of Telangana state, the need for doing a survey, the formation of a commission, rightly, wrongly. I'm not going into the merits. I'm sailing with the learned seniors insofar as that is concerned. Thereafter, they have talked about the bill being passed. Nowhere is there a mention of the Telangana Panchayat Act. The intention of the GO is to give effect to what was discussed in the bill. It is in their mind that this has been passed and has become an act. And then go on to say 42%. But what does the SEC do? SEC says, I am notifying under the Telangana Panchayat Act, and under that notification, and under that act, which has been amended by the GOMS 9.
Understood.
Therefore, my lord, this is a wholly wrong, arbitrary, legally illegal, legally incorrect notification, my lord. Thereafter, my lord, my contention and my humble submission is, my lord, there are very rigorous standards in a democracy for the constituents to know what are they going and voting for. They are exercising their franchise. When they are exercising their franchise, there are multiple judgments. Today, everyone is required to declare their assets, required to be above board, my lord. However, by this statement that there is an amendment to the Telangana Panchayat Act, there is a wrong misrepresentation that is being made by the SEC to the public at large, my lord. And in view of this wrong misrepresentation, rightly, intentionally, non-intentionally, I'm not going into that, my lord. My lord, there are judgments which say that 329B bar will not be attracted when there is a mala fide action or an arbitrary action by the Election Commission. That being the case, my lord, making a general misrepresentation to the public at large. So my argument, my humble submission is twofold, my lord. On the face of it, prima facie, this notification is bad in law. Now, the second humble submission is there is a misrepresentation being made to the public at large that this election is blessed, my lord, by the powers that are under the Telangana Panchayat Act, which is clearly not the case, my lord. So on both these limbs, my lord, these notifications are bad in law, dehorse, my lord, the other issues that have been raised with respect to GOMS 9, my lord. Therefore, they merit to be stayed, my lord. And if at all, my lord, my eventual prayer is elections, if they are to be conducted, they should be conducted squarely as per the Telangana Panchayat Act, as it stands today, as there is no amendment. My lord, with that I will conclude. Much obliged.
Lord, the petitioners before is, Lord, the appearing for the 305552. Lord, today morning I mentioned. Lord. The case of the petitioners are like this, Lord. Lord, we welcome the increase, Lord, the BC reservation from the 24% to 42%. But we differ on the one aspect that the Vikas Singh says that there is a triple test. Lord, the triple test first parameter is that I may be permitted to read, to set up a dedicated commission to conduct contemporaneous, rigorous, empirical inquiry into the nature and implications of the backwardness, Lord, the backwardness local bodies within the state. Now, Lord, I represent the most backward communities, Lord. Lord, initially in the state of Andhra Pradesh, Lord, in the year 1970, Lord, in order to give a reservation to the backward classes, Lord, under the Inquiries Commission Act, Lord, the Anantaraman Commission is constituted by the state, Lord. That commission, Lord, empirically collected the data, Lord, examining all the stakeholders, including the local inspection, has, Lord, come up with the report, Lord. In the report, Lord, the Anantaraman Commission report recommended the 30% reservation because 54% BC population are found. They deserve for the 30% of the reservation, Lord. The state of Andhra Pradesh, Lord, under the GO 1793 of 1970, my lord, initially, my lord, they adopted the Anantaraman Commission, my lord, by allocating the 25% reservation to the backward communities, my lord. The Anantaraman Commission suggested that the certain communities are there. Those communities are most vulnerable, depressed, the decades onward traditionally suffered communities are there. Those communities must be given priority for their upliftment, both in employment and education. On that purport, the commission itself, unless until categorization is not done among the BCs, the most backward communities will not be tabled, will not come into the mainstream. They will not enjoy the fruits of the constitution. On that premises, the government for the past 75, the 30 years, 50 years implemented the reservation for the education employment basing on the categorization. Whereas in the Telugu states, in 1994, the BC reservation was first time given in the local bodies in 1994. In the 1994, though BC reservation was provided 25%, the BC reservation is not categorized at that point of time in the political representation. Because of that, the experience shows and statistics before my lords that the marginalized section of people for the 30 years, they not properly or ignorably represented in the local bodies. There is no, categorization is already done, adapted by the state. There is that categorization is also upheld by the Supreme Court in Balram case. The Balram case, the judgment, I quote the only one param, the affidavit, I placed the Balram case, 171 page, my affidavit, page number 12, sixth para, page number 12, I am permitted to read bottom. It is submitted that experience of the past 3 decades has proved beyond doubt that the policy of treating the backward classes as a homogeneous group has resulted in a grave injustice to the most marginalized sections within the backward classes. The Anantaraman Commission 1968 categorically observed that certain communities within the backward classes are semi-nomadic, semi-beggar communities surviving under the conditions of extreme deprivation without social respect and equal treatment. Taking note of this ground reality, the state of Andhra Pradesh, Telangana adopted the recommendations of the Anantaraman Commission report 1970 and implemented through the GO 70, whereby backward classes were subcategorized into the BCA, BCB, BCC, BCD groups. Constitutionally of supervision was upheld in the case of the state of Andhra Pradesh versus Balaram 1972. The relevant portion of para 97 extracts is like this. Regarding the criticism that the commission has divided classes into more backward and less backward, in our opinion, this is not also well founded. On the other hand, what the commission has recommended was the distribution of seats amongst the reserved classes in proportion to their population. This is not a division of the backward classes as more backward and less backward, as was the case which was dealt with by this court in the M.R. Balaji case. Now question before my lord is that the commission conducted collected the data survey for the purpose of Article 15.4 and 16.4. In order to accommodate in employment, in education. Whereas local body reservations are concerned, in the Krishnamurthy case, the court differ that the data available with the state, which is collected for the purpose of providing education, reservations in the education and employment, cannot be adopted for the purpose of the local body elections. Lord, in the Krishnamurthy case, the court made an observation that there is an overbreadth of the BC reservation in Karnataka state, where 90% of the population in the Karnataka belongs to the backward communities. Therefore, that principle cannot be applied. My humble submission, Lord, the experience shows this state is concerned. For the 30 years of implementation of these communities, Lord, there is no representation. Lord, I take my lords to the one paragraph in my affidavit, my lord. I extracted some of the one report from the Anantaraman Commission at page number 21 for a minute, my lord. Page number 21, my lord. I am permitted to read. The Anantaraman Commission report gave a reasons, classification into groups and the basis for the inclusion, occupation, literacy, land holdings. The state government, after examination of the commission's report, adapted with certain modifications in GOA number 77, prescribing reservation of 25% to the so and so. Lord, I extracted the appendix 6 of the Anantaraman Commission. The commission says
We have
now
followed. Submission we have followed. You need not read out those parts.
this only para, my lord. I leave to my lord. This para I will read and leave. This para
I
shows
would not have interrupted, Malas.
certain-
I would not have interrupted.
Lord.
My lord has been patient for 2.5 hours, Malas. Now every intervener will argue, then we'll not get our chance, Malas. I just wanted to take a very
The
brief.
petitioners should also understand we are requesting them to conclude.
Lord, I
2.5 hours
will
is
finish
also
by
patient.
reading this only one sentence, my lord. I will leave, my lord.
We have followed your submission. Do we not expect that we have that kind
Only
of
single sentence. Only single sentence. My lord. These 2019 communities, my lord,
when you make 2-line submission, we follow 4 lines out of that. Please understand.
my-
So it is not necessary to read all those. We have followed your gist of your
yes,
submission.
only last submission, one sentence, my lord, for my satisfaction, my lord. My lord, the 19 communities were, my lord, which are found now existing BC list, my lord, their original traditional occupation is begging, my lord. I extracted the Anantaraman Commission report. Now, the advanced communities among the BCs, the clubbed with the weaker sections of the most backward who are watchmen at the graveyards, my lord. Many people. So this disparity, my lord,
This
we
is
never
not-
see the day of the light.
This
We never
part-
see, even future also, my lord, unless until categorization is not done, we will never enjoy the democratic, Lord, the fruits of the constitution, my lord. My humble submission is, without sub-categorization, my lord, it cannot be accepted, my lord.
WP number, my lord, item 23.
Oblige, my lord.
3050.
No.
My lord.
Please don't intervene like that. He was asked to make some. Just one.
2 minutes, my lord. Thank you for accommodating. Uh, with your permission, my lord, I'll bring new dimensions and new grounds to this issue.
Please understand that this is not a final hearing of the matter.
But let me tell only 2 minutes, my lord. 120
so
seconds. 120 seconds.
quickly
I'm a
make your
corporate lawyer. I came for pro bono for farmers, probably unconventional and but pertinent for this case, because my submission is, if you see this, what we are being, GO is relied upon.
Which is your writ petition?
Writ petition is implete petition 22.
Implete
But
people-
one
No. Implete people are yet to argue. There are so many in waiting.
one,
in the
one,
please don't
I am asking
insist.
one, only one request, my lord.
No.
No, I want to bring one word to the.
No. When I say no.
Oh, fine. Okay. Thank you.
My
Thank
lord,
you very much.
my lord, one more.
No.
My writ petition is penned. Item number 23,
Yes.
my lord.
Don't test our patience.
My lord, my
Yes,
petition
Lord.
23 for sub-categorization of the BCs. I am supporting the 42% of reservation sub-categorization.
Yes,
As per
Lord.
the Panchayat Raj Act, my lord, section 9(4).
Yes.
Well, it's for the state, Malas, if I may be permitted your lordship.
Learned AG is also on legs. Mr. Singhvi, you will be addressing on behalf of the state or both of you?
If your lordship will permit and with the permission of the learned AG, my lords.
Whichever convenience suits both of you.
Yeah, Advocate General may
Yeah.
start
There's,
after Dr. Singh.
May I, my lords, just point out?
So, learned AG.
May I, my lords, can your lordship hear me?
No. Yes, it seems that learned AG has given you
Yes.
the consent to. Yes, Mr. Singh.
I'm very grateful. I'm very grateful. Now, my lords,
Except that your audio and video is not.
itemize
Except that your audio and video is not very seamless. Video is also getting interrupted, and
Can your lordships hear me?
Of course we can hear you, but it's not seamless.
Well, let me attempt. Well, I'll have another platform, but I will go a little slowly and loudly. Well, please have another platform.
Except that.
Well, I wish to. Your lordship will tell me if your lordship loses me, Malaz. Otherwise, I will have to do something. Please have another platform.
No, you can join from another platform. Meanwhile, learned AG may address.
Well, I've got the platform ready here.
Yes, let's see whether this has enough bandwidth.
Now, Malaz,
Yes.
I wish to say at the outset, on the 4 or 5, 6, 7 points which arise, your lordship has said more than once that this is a hearing for interim relief. In my humble and respectful submission, your lordship has patiently heard, Malaz. I would say, Malaz, with some respect, there can be something called excessive natural justice. With excessive natural justice, for over 2 hours, and I don't think much is left for final hearing. This is not the remit of an interim proceeding, the way it has been argued. So that's my point 1. But anyway, Malaz, that is behind us. My second point is, Malaz, that your lordships at the interim stage is extremely hesitant in the rarest of rare cases, in genuinely, Malaz, cases of emergent exigencies and rarest of rare, to, Malaz, deal with in terms of staying a unanimously passed legislation across the political spectrum. Now, let me clarify, Malaz. Please don't misunderstand me. I am not suggesting that your lordship's power of judicial review doesn't exist. It is more than ample. Where absolutely necessary, your lordship's power of judicial review reaches every nook and crevice. But, Malaz, it is rare to find in today's, Malaz, fractured consensus across legislatures that this legislation, the effect of which is under consideration, has been passed unanimously across the political spectrum. I don't know the exact values, maybe there are 1 or 2 non-yeses and non-ayes, but rarely would my lords find such a heavy one-sided aye motion for one legislation, irrespective of political color. That gives added weight to something which, of course, your lordship will strike down or interfere with in the case of a genuine, real, rare, extreme case. It is not to deny the power, but your lordship will exercise that power extremely sparingly. Keeping this very weighty factor in mind is my first point. The second point is, Malaz, that there is a very great paradox here and a contradiction here in what my lord is seeing. The paradox and contradiction is this, that your lordship has no challenge, at least in the last 2 hours which your lordship has been hearing, to the legislation. Your lordship instead is being told about the vices or the errors of the consequence of that legislation. The legislation is not challenged. In fact, the prayer, if your lordship will see page 20 in the first writ number at page 20 has no challenge to the act. Item 5. Page 20 will match with item 5. Why don't you speak? 30274 is, I'm told, item number 5, right? The prayer is at page 20. So your lordship has the contradiction and the paradox that the legislation, which is the fountainhead of the power, is not under challenge, but the inevitable, inexorable consequence of that legislation is being challenged without challenging the legislation itself. That's point number 2. Point number 3. If you choose to challenge only the GO issued under the powers given by the Act and not challenge the Act, then the maximum you can do is an argument of ultra vires saying this GO is beyond the four corners of the Act. There is no other challenge possible or available. Yet your lordships has been told far and wide ranging arguments which will suggest as if you will be asking for relief without challenging the parent power under which the GO is issued. These are extremely important for the interim stage, Willis. Which brings me to the related point that in such matters, if at all your lordship entertains it, it's always made, Willis, as a third submission, subject to the outcome. There is no question of staying the effect of a legislation substantively providing for a power with the substantive legislation not under challenge, not argued for 2 hours under challenge, and passed across the political spectrum. At the highest, it will be subject, everything will be subject to the outcome. There is no question of us asking for a stay in this manner of the entire exercise. That is, Malas, my point number 3. Now, Malas, point number 4, of course, let me say, Malas, the whole argument in the last couple of hours has proceeded on a fundamental fallacy, which I'll be coming to a little later. The fundamental fallacy is that your lordship has a constitutional bar, like a prohibitory negative constitutional injunction, thou shalt not exceed 50%. It's a very simple slotting machine. Count the numbers, come to 51% and strike it down. That's been the approach. That is completely fallacious in law. There is no absolute, inflexible, constitutional negative prohibition on the 50% cap. Never has been, and in particular it has been clarified. But I will come to that a little later. Also note the second fallacy, I'll expand and elaborate why these are fallacies. So fallacy number 1 in principle in law, that the moment you exceed 50%, there is a constitutional bar. Fallacy number 2, that all the judgments which have struck down are judgments because there is a bar. Not at all. The judgments, in fact, recognize specifically the power to exceed 50, but say that it must be based on proper exercises of informing and educating yourself, of collecting relevant empirical data, and if that exercise is done, on the contrary, we hold that public interest, societal interest, requires a fair representation of the cross-section of people in society, and therefore the government, and through the government the legislature, will have the full power of taking that policy decision based on the empirical data to exceed 50% so that they can give true representation to the true sections of society which deserve that, and that's purely a governmental and a legislative decision. So that's the second fallacy, because in this case, there cannot be a more greater dedicated exercise to ascertain that, unlike in one or two cases where it was done in a hurried manner and not done properly. That I'll be dealing. And the third head will be that there is in fact no law. So you very nicely assume in your own favor that there is no legislative backing for what I am doing. Because I had the privilege of assisting the court as the lead counsel in the Tamil Nadu matter. It is one of the most detailed exercises assiduously done by that bench, not only in terms of length, but every aspect of Indian and foreign law was seen. And there is a specific constitutional direction that there is, if you do not pass it, a deemed assent after 1 month. I was amused to hear that the powers of limits of 142 were being stretched, as if that's an argument open to us in the High Court or to counsel for the petitioners or interveners. And I will deal with that also. So let me just come one by one to these three fallacies which are involved in the heart of this case. After my first 3 points I made, now let us first consider the over-detailed empirical exercise done in this case. No other case has had such a thought out, considered and properly done exercise. And my learned friend Mr. Siddhi will give your lordship a short note with the list of dates which will show your lordship the exercise, then I'll show some pages. Kindly hand over quickly. The list of dates note, the first page note, the 2-3 page note.
Yes.
So first, fellas, I'm only showing those items in the list of dates which deal with that exercise to inform and educate and collect data. If your lordship will come to number 3, the original act way back in 7 years ago in 2018 was the Panchayati Raj Act. At that time, this exercise had not been done, and your lordship is aware of 285, etc., which gave that original ceiling. Then my lord comes to number 4. Now, this was the flexibility and the change in the constitutional scheme. 2019, you had the so-called 103rd Amendment, and it brought in the 10% reservation for EWS. Now, please note that if there is in fact an absolute bar bordering the basic structure bar, then you could not have had this exceeding of 50%. Because the original reading was that there's an absolute bar from Mysore onwards in the 1960s, a 50% bar. Just the EWS by itself takes it to 60%. That's in item 4, 2019. Then, Malads, comes in item 6. We are now in December or November 2024 last year. This is a detailed socio-economic, education and employment particular census undertaken by the state, which gives this figure, and I'll be reading to your lordship the executive summary of this. Now, I am the state. I have come here giving your lordships the actual executive summary of this study. Who is the petitioner to say that, please, this is done without anything? Is this a forgery, Malads? When our time comes, etc., we will file a proper reply. But for giving a stay, I am showing you, Malads, a detailed, and I'll show the pages, a detailed Malads report which shows that care was taken to ascertain genuine numbers. Either, Malads, your lordship is told that you will find there's an absolute bar, in which case Making an effort, finding empirical data, no point. Whether it is 56% or 59 or 62, it's a bar. So what's the point of collecting the data? On the other hand, if there is flexibility based on informed decision making and data, then your lordship will look at the exercises undertaken because there's no absolute bar. Then what is the next item after item 6, which is November, December, which I'll read in a minute, is Malas item 7, where a one-person commission, because the first the data is collected, it's massive data. Then there is a commission. Look at the painstaking, multi-layered institutional decision par excellence. There is a data analyzed by the one-man commission, and that also I will read, your lordships. Item 8, the one-man commission, one-person commission gives a report, detailed report, which I will be showing Malas, that in the light of the previous two items, a minimum of 42% is justified as reservation in the local bodies for BCs. After you have 7, 8, or rather 6, 7, and 8 serial numbers, then Malas, an informed decision is taken to pass the bill, which ultimately the learned governor sits upon. He neither returns it nor assents to it. That is important, item 9, 17th March. It is not 1 month, Malas. It is over now 6 months. Neither assent nor return. They are sent 5 days later on item 10 on 22nd of March. Now, Malas, two more items, 11 and 12. According to us, that became law long ago. That is, item 9 became the law long ago. Then item 11, an ordinance is passed because we are doing this, well, it can be done in many areas. This particular area is the Panchayati Local Self Bodies Act. So we do the amendment correspondingly, consequentially, parallelly in the Panchayati Act in item 11, or the Panchayat Act in item 11, which is in a sense consequential and parallel. And then, Malas, further, there is an independent expert group to analyze. So this is the fourth element. Actually, third, you would say. The socio-economic study, the one person, and then this is the third. It is this report, having analyzed the data already collected, then leads to the 26/9/2025 GO, which is purported to be impugned without challenging the act. Now, Malas, just turn to a few pages of what I am showing, Malas. Mr. Siddhi will kindly hand over volume 2, which has got these executive summaries of these reports. I'll call it volume 2, which is what my note calls it. And please come to, Malas, page 139 of the volume 2. Mr. Siddhi may kindly hand over. Now, Malas, we are here to show a basis, a broad reason why your lordship should not pass any interim order. We are not here to argue it finally. We have yet to file a detailed counter. Your lordship is being presented as if this is an unthought out, ad hoc, arbitrary, knee-jerk reaction. No data, please state. All that we have to show is to satisfy broadly, my lords, that look, there is a lot of work which has gone behind this, and such a legislation not challenged, not argued, and a geo consequential to all these exercises should not be in any manner interdicted. Everything will abide finally by your lordship's final order when the matter is heard finally. 139, if your lordship, I'll only read 2 or 3 portions of it. I won't read much of it. My lord has got it. Was 139?
Just a minute. Yes.
the Council of Ministers resolution of 4th of February, the Assembly passed a following resolution. Now, actually, we take it for granted, but in today's day, as I said, today's days of fractured consensus, even for ordinary bills, this is a rare phenomenon. Having had some experience of that side of the bar also, this House unanimously resolves. This phrase, I don't think your Lordship finds normal life very easily nowadays. The reverse is true normally, on every small thing there is a fight. This House unanimously resolves to undertake a comprehensive door-to-door family survey caste census across Telangana, covering social, economic, educational, employment, political and caste aspects, as per the recommendation made by the Telangana Cabinet on 4th of February. This initiative aims to formulate and implement plans for the social, economic, educational and employment advancement of backward classes, scheduled castes, scheduled tribes and other major sectors. Now, actually, this itself is liable to be struck down and challenged because I have no power to do it. There's an absolute bar. Why this exercise should have started at all? Government have issued GO of 10th of October directing to take up a comprehensive door-to-door of entire Telangana so as to plan and implement various socio-economic, educational employment. Next page 140. Has constituted a committee under the chairmanship of Minister of Irrigation, etc. Planning department is designated as the nodal department to understand the methodology and learn the best practices from other states. Caste surveys done by Karnataka and Bihar governments were studied in detail. Look at the painstaking exercise and in an interim order at the preliminary stage without pleadings being complete, without final hearing, your Lordship should state. The learnings from the experience of other states have been incorporated into the design of the SEPC. Further, widespread consultations were held with all stakeholders. Their input suggestions were taken into account. Based on the widespread consultation, the following documents were prepared: house listing schedule, household survey, guidelines for enumerators. Types of information collected in the survey. The survey had a total of 57 questions, with further sub-questions making a total of 75 fields in which aspects of social, economic, educational, employment, political and caste was collected. Survey methodology. Each district in the state was divided into enumeration blocks with each EB consisting of 150 households. Accordingly, a total number of 94,000 enumerations was created. 94,000. One enumerator was appointed for every enumeration block and supervisor appointed for every 10 enumerators. Accordingly, 1 lakh enumerators, these fanned out across the state. And on the last day, they came for the first time on 27th. The exercise is going on, and then second date is today and they want to stay now. Then the status of the physical survey. The socio-economic survey started on 6th November with house listing. During the first phase, house listing was conducted for 3 days, etc. Now ignore that, just glance at 142. All the details are given: physical survey, total number of households, data, 36 days. If your Lordship doesn't mind, I'm doing speed reading. I'm only asking your Lordship to have a synoptic view, not in terms of content, because your Lordship is not sitting in judicial review on such things. But just see the painstaking nature of the exercise. Then come to 143. Survey final results after the second phase. Again, the numbers and the details don't bother your Lordships, but look at the population, 3 crore 54 lakhs, unsurveyed households, house listing. But just see the top in the middle of page 143, 97.10 household surveyed. I hope my Lord has got that 97% in brackets.
Yes.
Then 144, state level population. Now, is a state which is the elected representative of the people so impotent and so helpless that it can't find out that its own people constitute 56% of the BC at page 144. It is not to, so on this will depend your local power, your local self-government. Tomorrow it may depend on educational institutions. Day after it may depend, on this may depend your Lordship's employment ratios. What is wrong in the state taking a call as the elected representative? Ultimately, the representative, the electorate will throw them out if this is all wrong, being done too much to favor one class. But can this exercise followed by an act of the state legislature be stayed in this manner is my question to myself. With the deepest humility and respect, I say, how can this be raised? Then, Malus, page 144 has got the BCs in each category. I'm not troubling your lordship, but look at Malus, the large numbers. In phase 2, the number was 70%. In phase 1, it was 56%. The average came to some 56.36 because the weightage in the first was larger. But we've got the third figure, 56.36. And then, I end. Of course, there is a social category-wise detail in page 145. And then 146, very scientific, very considered. Then comes, a further independent. So, there's a multi-layered, I called it multi-layered institutional decision par excellence. It's not just raw survey. That raw survey is then, looked at by a one-man commission and further by an independent expert working group. So that, comes to 146. The advisory committee constituted under the GO was decided to constitute independent expert working group to carry out the analysis conducted by the government for formulation of evidence-based policies on various sectors. Constituted an independent expert group with the following composition: a retired Supreme Court judge, a SC, ST and backward classes expert, then technical these are professors, teachers, practitioners, and very eminent Thomas Piketty is a world-renowned authority, an author, world-renowned. Jean Raj is a world-renowned author and authority. Nikhil Dey, Sukhdev Thorat are all academics of great repute. You may not agree with it. You may agree with it. You may not agree. Petitions, I'm not asking for petitioners' consent. But the exercise is as scientific, sober, detailed, repetitive, and analytical as can be. Then 147. The IEG will analyze and interpret the SEPC survey 24 data and submit a report to the government within a month. So-and-so district collector will act as secretary. Conclusion. The survey has been successfully completed in all aspects within 1 year from the Council of Ministers' decision, demonstrating efficient execution. Data will be used to formulate evidence-based policies for the welfare, not only of BCs, but of SCs and STs also. This initiative reflects, etc., our commitment. The one-man commission came before, and that your lordship gets in the same volume at page 18. After the survey, in between, there was a one-man commission, page 18, or a one-person commission at 1.8.
Yes.
Appointment of Sri Rao, IAS, as one-person commission to conduct contemporaneous, rigorous, empirical inquiry and analysis. In point of time, this happened after the data collection list. The IEG came later. An analysis and recommend the percentage of reservation in local bodies, educational institutions and appointments. This is both a technical, a statistical and an analytical exercise. It's also statistical very much. Then government in the GO, so they list 2 GOs above, and of October and November 2024. Government in the GO read above have ordered for special economic, education, employment, etc. This survey report was placed before the Council of Ministers and later the matter was discussed in both the houses. And the Honorable Chief Minister made a statement. In the GO read above, Sri Rao was appointed as a dedicated commission to conduct a contemporaneous, rigorous, empirical inquiry into the nature and implications of the backwardness. Nature and implication of the backwardness to a local body. So today, one of the initiative is local bodies. Tomorrow, lordship may have in education. The after lordship may have in employment. But we will do a more rational thing by having data. You won't be shooting in the dark. Local bodies within the state of Telangana to specify the proportion of reservations to be provisioned local body wise. This dedicated commission conducted field visits, interacted with various backward classes, political, etc. Para 3. In view of the above, government hereby appoints Sri Rao as a one-person commission for studying and analyzing the empirical data of the SEC caste survey and other relevant data and material for recommending the percentage of reservation in the local bodies, in the educational institutions, and for appointment in the public service. So my lord has got both here. The one-man commission shall submit a comprehensive report to the government as expeditiously as possible, etc. The matter ends on that. Now this is, the maximum the maximum your lordship will get in any case up to date in terms of empirical exercise for data. I'll show that in a minute. Unless the law is that you can never exceed 50 to 51% per se, in which case all exercises are futile. This is clearly within the mandate which allows you to exceed based on rational data. That's the proposition. Now, I turn to that. I asked myself, if there's an absolute bar, the mother of all these is the 9-judge bench in Indira Sani. Why was that flexibility preserved? The flexibility is not limited, as was sought to be presented to your lordships wrongly, that the only exception is far-flung areas. Suppose your lordships on a survey, forget this case, a state government elected by the people finds on a survey that the population of BCs is 80%. There are some states where it is 70%, some people say already 80, which are not surveyed. And it says that, look, we can't have large sections of our populace. We are the elected people. We take a risk. If the people don't like it, we'll be voted out. It's our decision. We want representation based on this data. Can it be said that no, unless you show that these 80%, the majority of them are in far-flung, inaccessible areas, only within 50 you can give, everybody else should be excluded. That is not Indira Sani at all. Now let us kindly come to that. First turn to para 810 at page 735 of the SCC. 735 of the SCC is, they already are using it. Use it 10 times. Your lordship has used the Indira Sani already. You lordship will use that, or you lordship will use my volume, whichever your lordship likes. 810, the SCC page is 735. If my compilation is given, it's page 724, whichever your lordship would like to use. Kindly, Mr. Siddhi, kindly give our compilation, Mr. Siddhi. So in my compilation, the compilation page is 724.
Which volume?
3, volume 3, sub-volume 2. There's some 2,000 pages, your lordship's judgment sometimes quite long, to put it mildly. If your lordship checks up Justice Madholkar's judgments, no judgment occupies more than 4, maximum 5 pages of the SCR in the 60s.
Which is the relevant paragraph which you are referring?
810, compilation page 724, SCC page 735, para 810.
No, volume 3 starts from 1001.
Mr. Siddhi, please give the correct one.
He has given all the volumes, but I think
volume 2, that was my mistake. My learned friend instructed me.
but
Maybe
that paragraph has been read over time and again by all of us. So,
well, it's only from one perspective on one side. This is the first time this perspective will also will. Perhaps others may not be reading it on our side, but this is our perspective.
you referred to page.
My SCC page will be better once the lordship has got the judgment in front of you. SCC printed page is 735. My compilation page is 724.
724. Seven to 4. Yes, we have got it.
Now we'll look at the structure. They are clearly saying that normally it is 50, but we do all this because it is not an absolute bar. This whole argument now is absolute prohibition. The structure and the language of the paragraph is to be seen. While 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of the country and the people. Full stop. One extraordinary situation is a overwhelming large population of BCs. That is, of course, a very important thing. Now, this is only illustrative. The next sentence is an example. It is not exhaustive, that your lordship will not go beyond far-flung areas. It might happen that in far-flung and remote areas, the population inhabiting those areas might, on account of their being out of the mainstream and in view of conditions peculiar to the characteristics of need to be treated a different way, some relaxation in this strict rule may become imperative. Now, this is one example they thought of when they gave it. What is being read is this is the only exception you can make. If there is no far-flung, out you go, no 50% excess. That's a wrong approach. Even in doing so, extreme caution is to be exercised. Now come to para 859 at page 755 of the same compilation, where the conclusions are summarized. In these conclusions, if your lordship comes to the next page, 756 of the compilation, number 6, at the bottom of 756, number 6, does my lord have it?
Yes, yes.
A and B, the reservations contemplated in clause 4 should not exceed 50%. While 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity. It may happen that far-flung, same thing is repeated. Same thing is repeated. Now, Maras, come to a more recent judgment after much water is flown, wrongly and distortedly interpreted to be against me, directly in my favor, Janhit Abhiyan, Constitution Bench. I had the occasion to assist the court in this palace, and your lordship will see, they emphasize the availability or the non-availability, as the case may be, of palace data. Otherwise, there is no absolute bar. Please come to Malas. Let's just come to 166. Justice Sawant's paragraph is quoted there. Does my lord have this? Para 166, page 1313 of the compilation. This is volume 3. It's volume 3, Malas, I'm told.
3.
Yes.
So, Malas, Justice Sawant is quoted in para 166 at page 1313. To summarize, the question may be answered thus: there is no legal infirmity in keeping the reservation exceeding 50%. Does my lord have that sentence? First sentence.
Just a minute. Yeah.
I'm sorry, para 166.
166.
Yes.
Well, they are quoting Justice Sawant from Indira Sani. See the first sentence. To summarize, the question may be answered thus: there is no legal infirmity, that's very important, in keeping the reservations under clause 4, etc., exceeding 50%. However, validity of the extent of excess over 50 would depend upon the facts and circumstances of each case, including the field in which and the grade or level of administration for which the reservation is kept. Now, Malas, your lordship is to read just that one line of far-flung and ignore all such, well, other 9 judges are discussing in different ways. Next sentence. So there is a flexibility in the joints depending on the particular context. Although further legally and theoretically the excess of reservations over 50 will be justified, ordinarily be wise and nothing would be lost if the intention of the framers is kept in mind. The reservation should be further kept category and grade wise at appropriate percentages. Then, Malaz, please see para 169. This is a convenient judgment because it quotes the relevant parts of all the other judgments. Para 169.
Yes, yes.
In Jayashree Patil, Justice Bhatt, after analyzing Indira Sahni, said, a careful reading of the judgments in Indira Sahni clarifies that 7 out of 9 judges concurred that there exists a quantitative limit on reservation, spelled out at 50%. In the opinion of 4 judges, as per Justice Jeevan Reddy's estimate, this limit could be exceeded under extraordinary circumstances and in conditions for which separate justification has to be forthcoming by the state. However, that there is unanimity in the conclusion of all 7 that an outer limit for reservation should be 50%. Undoubtedly, the other 2 judges, Justice Pandyan and Sawant, indicate there is no general rule of 50% on reservation. In these circumstances, given the general common agreement about the existence of an outer limit, the petitioner's argument about the incoherence or uncertainty about the existence of the rule, or that there were contrary observations with respect to absence of any feeling in Tevadasan, etc., or these other judgments of the next page, brothers, is not an argument compelling a review or reconsideration of Indira Sahni.
Yes.
Then, whereas 170, they say it has received constitutional significance, the 50% rule. Then come to 171. So they are at the moment quoting various judgments, including Justice Bhushan, Justice Bhatt. Thus, having examined the permissible limits of affirmative action in light of the possible harm of preferential treatment, this court has expressed the desirability of 50% as the ceiling for reservation in education and employment. But as observed herein above, all such observations are required to be read essentially in the context of reservation obtaining under 4, 5, and 4, that is 15.4, 15.5, and 16.4, or other areas of affirmative action like that in relation to local self-government. They cannot be overstretched to the reservation provided for entirely different class consisting of economically weaker sections. Because this judgment barred it, therefore, the constitutional amendment was passed for EWS. Because that time, there was never a doubt about BC reservation. The dispute was about EWS. I hope I'm clear. You could exceed 50% for BCs, but EWS was a new category. Then come to 172. So that is why this para was meant to as a bar for the EWS, which is why the constitutional amendment came. Then, moreover, as noticed, this ceiling limit, though held attached to the constitutional amendment, has not been held to be inflexible and inviolable for all times to come. That's extremely important. My lord has got that.
Yes.
Reasons for this are not far to seek. As mentioned here and above, reservation by affirmative action is not having trappings of any such essential feature of the Constitution as in Maharaj Keshwanand, and successive decision, that is modulation with reference to any particular compelling reason, could damage the basic structure. Now, Maharaj, what are they saying here? That this 50% can be flexible. You need not. Can I seek, Malas, 1 minute of your lordship's time? Just 1 minute, if your lordship doesn't mind.
Yes, yes.
Back to 600 pages. State aspect.
no legislation notified by that. उसके आंसर ये दिए हुए हैं मशीन में पर सेकेंडली गावली का ये लोकल बॉडी का थर्ड वाला 50% कैप ये गवर्नमेंट से वोटिंग सिस्टम WSS 16 employment with उसमें उनका क्या बोलेंगे इसी नोटिफिकेशन वगैरह क्यों नहीं निकालते डीम्ड वाले जो है अल्टीमेटली लॉ से नोटिफाइड होगा ना enacted in such and such date extraordinary gazette published in such and such लेकिन ये नहीं है बल्कि उसके बदले में एक ऑर्डिनेंस निकाला है ऑर्डिनेंस गवर्नर ने साइन कर दिया उसको भी तो केस ने वही चीज़ का एक ऑर्डिनेंस निकाला है तो ये हो गया सर्विस बैठ ये दोनों का जो लॉ पास हुआ है जस्ट इसके ऊपर रेलेवेंट लोग नहीं
My apologies, Vince. My apologies. So 172 is very important for the point that please don't think that the 50% rule is part of basic structure. It is not inviolable as basic structure, is what they are saying in India. Well, therefore, so long as you have data, the law provides no prohibition. Your lordship is an interim stage. There is no straight per se infirmity of 2 plus 2 equal to 5, which necessitates the stay. Now, the third and last point, or 2 more points, the penultimate point, is this complete misunderstanding about the nature of the act passed under the new regime of the Supreme Court. The Supreme Court, and I had the privilege of assisting the court in diverse cases arising prior to Tamil Nadu, from West Bengal, before that from Punjab, the very important judgment of Punjab, then Tamil Nadu, then West Bengal, then Tamil Nadu. In all these cases, there was a paradigm which had developed. Good, bad or indifferent, something never contemplated by Dr. Ambedkar or the entire Constituent Assembly, because everything is not written. Everything is not written in the Constitution. It depends on the spirit and good governance notions to run it. Across India, in state after state, where especially the political color of the state dispensation was different from the political color at the center. In some states, especially the 3 named now, which I just named, governors would sit on bills and neither return, nor assent, nor refer to President. Now, Article 200 has 3 very clear options, extremely clear. And the Constituent framers never imagined that you will find a 4th one, like a Trishanku, of suspended animation, of not doing any of the 3. So, that led to a situation where in Tamil Nadu, for 5 years, bills were kept pending. In Bengal, for years and months, it was kept pending, and the matter landed up in a Tamil Nadu petition before the Supreme Court. In that, the Supreme Court has given clear directions. There is no question of suggestive, no suggestion of advisory, as was argued in the morning. And no argument is open that, look, we will consider the stretching of the limits of 141, 142, therefore, lordship may ignore it. Now, let us see 3 paras of that judgment in the light of this one. Just note 2 dates before lordship comes to that judgment. The legislation is passed on 17/3/25. Please make a note of this.
Yes.
And the governor sending is on 5 days later, on 22nd of March 25. These are admitted dates.
Yes.
Now, your lordship knows, there's a very famous saying in the Constituent Assembly: no 2 swords in one scabbard. एक म्यान में 2 तलवार नहीं. The chief minister is the elected representative of the state. I always like to submit that the elected representative has the elected right to do right, to do good, but equally to do not so right and maybe wrong. That's his good luck or bad luck. It's his vivek. That does not mean that your lordship has a separate power in a governor to act as a super chief minister. There are no two swords in a scabbard. Your lordship will be surprised. We have all this reproduced. We had argued for Tamil Nadu Justice Padiwala to reproduce it. Whereas there were passages saying that Dr. Ambedkar said that we want to have a nomination. Sorry, we want to have an election of a governor. Not he, a lot of other people. He opposed it, saying that we are making it such an ornamental post. He used the word ornamental, not my word. That we are worried that nobody may want to become a governor. Then finally they settled for nomination. And then in the discussion they said this whole thing is done so that there is no power in the governor to second guess a chief minister. And 200, if your lordship picks up and reads for 30 seconds with me, is a clear tripartite distinction, and then I read the judgment. You must return, you must assent, or you may refer. Lordship, we just pick up the constitution for 30 seconds, please. Article 200. So please understand the context in which a helpless Supreme Court at the end of its tether with multiple judgments. This was preceded by Banwari Lal, a Supreme Court judgment authored by Chief Justice Chandrachud in Denver on the same line. But the actual time limit, because there's no point giving long sermons and not having teeth or not having a remedy. No point giving rights without a remedy.
27 days, including those 2 days.
Yes.
There is somebody who's competing with me on the mic. Anyway, 200. When a bill may I read, Malas? When a bill has been passed by the Legislative Assembly of the state, or in the case of a state having a legislative council, has been passed by both houses, it shall be presented to the governor. Now note this, Malas. 3 options only. And the governor shall declare either that he assents or that he withholds. Now withholds is covered in the proviso. Or that he sends it to reserves the bill for the considered president. Only 3. The second one they elaborate by saying that if you send it back and the legislature sends it back, then he is bound. Now here the error of the argument of one of the learned counsel in the morning is to omit the fact that the governor has never sent it back. I hope I'm clear about it. The governor has never sent the 7th March bill back. 17th March bill sent on 22nd March back. The question of the legislature sending it back will not arise. Therefore, now the paras of Justice Padiwala's judgment kick into action straight away. Please hand over the compilation, page 1831 it starts, volume 3, volume 4. And the whole purpose of this law was that you cannot paralyze state administration because you are second guessing the governor and the council of ministers. They have the right to do right, they have the right to do wrong. The electorate will deal with it or judicial review will strike it down. The governor can't withhold endlessly without declaring, without sending back, without sending anywhere else and sit on it. Squatting is not an option. Squatting on a bill sent to you is not an option. If you squat, then 1 month later, the bill is deemed to be passed. In this volume, it starts at 1831.
1831.
I will read 3 paras and the conclusion. May I read, Malas?
Yes, yes.
It's a long, detailed judgment. The bench labored hard and wide and across the globe. All precedents, entire Constituent Assembly debates. It's a very, very well written and a very comprehensive judgment after considering everything. And we argued it, Malas, over a period with the Monday, Friday interruptions of over 2 months. Now let us come to 3 paras in sequence, only 3, and 1 conclusion, 4 paras. First is para 240.
Yes.
That is at page 2037.
Yes.
Thus, it is important to take note of this very fine but pertinent distinction that the prescription of a time limit by this court into 200 of the Constitution does not fundamentally change the procedure which has been envisaged. While the reading in of a time limit under 200 would have meant that there would be deemed assent upon failure of the governor to comply with the set timeline. The prescription of a reasonable time period does not introduce any such mechanism or deeming fiction in Article 200. Well, I would beseech my Lord that replay study. I'm not reading in detail. Lordships can certainly read in detail. I'm only reading 3 paras, but it's something which really replay study. And I'm not doing justice to it by not reading it in detail. Then, Wallace, they say that this is not creating a new mechanism which is beyond the Constitution. It is fulfilling the Constitution. And they then do it actually in para 250 at page 2043. 250.
Yes.
The actual timelines. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Prescribed, not optional, not suggestive, not recommendatory, mandatory. Failure to comply with this timeline will make the inaction subject to judicial review. In case of either withholding or assent or reservation for the consideration upon the aided advice, the governor is expected to take such an action forthwith, subject to a maximum period of 1 month. That is the category for us. The return of the bill has not happened. That is the second category of 3 months. Wrongly told your lordships. That is para double I. There is no return of the bill. I'll tell you why also when we discussed this in practical terms and we argued the matter. Governors choose sometimes not to send it back because if I send it back and the legislature sends it back to the next day, then you are bound.
We have 2 questions. I've heard you quite length of, in fact, 3.
Well, it's just 5 minutes more and I'm done. 5 minutes more.
Very well. You can.
This judgment ends at page, the relevant part of this point ends at para 435, just above 436 at page 2240. That is para 435 bracket C at page 2240.
Yes.
And this is not the first case. It followed upon Punjab. Where I had the privilege of assisting the court in Punjab, and this Punjab is followed here and applied here. Having regard to the unduly long period for the time in which bills have been kept pending by the governor before the ultimate declaration of withholding of assent, in view of the scant respect showed by the governor to the decision of this court in state of Punjab, and other extraneous considerations that appear to be writ large in the discharge, we are left with no other option but to exercise our inherent powers under 142 for the purpose of declaring these 10 bills as deemed to have been assented on the date they were presented after being reconsidered by the legislature on 1811. That's the operative part. And the conclusions are subpara 9, small Roman 9, at page 2222. There is 2222. There's a long list of conclusions, if you should notice, it starts at 2218. 2218. If my lord will just turn to 2218 and note the first one. The 3 options are given. Only 3, no 4th option of just spotting. There is no 4th option of spotting. There are only 3 options at page 2218, para 434, small Roman 1. Assent, withhold assent, or reserve. There is no 4th option. Then, your lordship sees small Roman 9 at 2222. This is the law of the land now. The bills having been pending with the governor for an unduly long period, the governor acting in clear lack of bona fide and reserving for consideration immediately after pronouncement, are deemed to have been assented to on the date they were presented to him after being reconsidered. Then, as I end, just one point. I'll be very sorry. I'll just await your lordship's query after that. There is a general principle that your lordship, even if the act was challenged directly, does not stay the operation of an act, except in exceptional circumstances. Your lordship is aware of that principle. Cases have held it repeatedly. Here, without the act being challenged, the inexorable consequence of the act, the GO, is sought to be stayed on the last day of the before coming into force, and your lordship should not even say subject to outcome, is the case of the petitioner. There is no operational fetter or stay on the judgments of the Supreme Court in Punjab and Tamil Nadu. The misleading impression given by certain advisory opinions which have been referred, there has been no stay and there is not an appeal. There is no intra-court appeal in the Supreme Court. The Supreme Court is final. It is right because it is final. It is not final because it is right. Ultimately, you may go in reviews and curatives, but it is right because it is final, and there is a finality attached to it. Those are my submissions. I would at the end beseech my lords to not nullify such a detailed, well thought out, intensive, analytical, bona fide exercise in the prerogative of the elected members across the political spectrum, all of whom believe that this is good for a state. By an interim order before completion of pleadings without final hearing at this stage, and most of this can be achieved by making it explicitly subject to the outcome. I'm done, Manoj. I'm very sorry I interrupted your lordship. Lordship will put those questions to me.
There were out of number of points that were urged on behalf of the petitioners.
Yes.
I would pose the 3 points which we feel you need an answer to.
Yes.
As it appears from the chronology of your dates,
yes,
after the bill was sent to the governor and the period as per the Tamil Nadu judgment was over,
yes,
if the government in power felt that it is a deemed consent, was it notified? Probably not.
No, but the whole purpose of deemed consent as we understood it.
No, so therefore,
yes,
what we understand that therefore in July an ordinance was passed.
Yes, yes.
So this government was also not under an impression that it was a deemed consent and therefore the necessity of a ordinance. Now ordinance is as good as law with its little time limit which it has for its life.
Yes.
So this is the first issue, that if the government thought about a deemed consent, it has not notified, but instead
may I just clarify, Manoj? The bill which was sent for the governors and which we say is deemed assent is the 17th March 25 bill number 9.
Right.
In my literature. The ordinance is to the cognate parallel act regarding the Panchayati consequential act. That is the consequential act. I am putting this reservation into panchayats. Tomorrow I will put it into education. Day after into public service employment.
So then that
the amendment is the consequential thing where I want to place the reservations.
So then the 17th March bill which was passed was not notified as yet.
Whereas the bill is once it is deemed assent act, it is self-operative from there.
No, for the people to come to know that it is an act, there is a further act of notifying it in an extraordinary gazette to be made effective from a particular date.
Well, that the learned AG, I am told, has that document, whereas I don't have it. It was recognized and acted upon and known to the public.
Subject to
that is one.
Clarification.
But your lordship may clarify that this ordinance is about the Panchayati consequential, not about this one.
Do you? We have not seen that July 2025 ordinance.
Yes.
But the 2 bills relating to amendments to the Panchayat Act and the Municipalities Act, which were passed in late August 2025 and have been sent to the governor, they are also awaiting assent. But
yes. But the ordinance is on the record of this volume, page 121. Which I
very well. So does
volume 2.
The ordinance is for amendment to the Panchayat Act or Municipalities Act or both?
Panchayat Act.
Okay,
That
so
is the 2018 Act.
so the relevant provisions which were finally passed by the Legislative Assembly in late August, they were already promulgated by way of an ordinance in July 2025.
Correct.
Is that
Correct.
very well? Secondly, judgments all of both sides have referred to in matters of reservation to these local bodies. There is a judgment of three-judge bench in Gauli's case,
Yes.
where the again triple test has been reiterated.
So I'm very grateful. I'm very grateful. The answer is there clearly, and we satisfied.
No,
Please turn to Gauli.
Let me first
I'm sorry. My
articulate the
apologies.
full question.
My apologies.
So, all the judgments in Indrasani or the later judgment which you referred to, they propose a general exception in exceptional circumstances that the sealing is not sacrosanct.
Obliged.
But the Gauli's case, in a case of a local body itself, says 50% is sacrosanct. Now, how does the state or any state for that matter get over it? All these ceiling limits which are being crossed by different states, they ultimately are being challenged and are being taken up.
I appreciate.
So this Gauli judgment.
May I answer, brothers?
And third, so that you may also think over the third issue, the local areas in which all these panchayats are there, they may have different proportion or demography or levels of representation or presence of backward classes. But this GO 9 uniformly applies that 42% across the state. Whereas if the empirical exercise is done like it was done, say, in some other state, then it could have been tailor-made to the requirement of different panchayat bodies in different districts for that matter, instead of a wholesale uniform 42%. There, whether sufficient application of mind has gone into that or not by the commission or by the body collecting the data and the government which has accepted it.
Yes, please. May I answer, please?
Fourth question.
May I answer, please? Just 2 minutes.
There is one more question which my brother rightly.
Yes.
That after this data etc. are published and the commission submits a report, is there not a requirement for publication and inviting objection and then dealing with the objection and accepting it?
Right, please. I appreciate it. May I answer, please?
Yes.
So let me answer, please. First of all, let me take the last point. Yes. This is a exercise for a government to make a policy decision, then on that policy decision to pass an act of parliament of a state legislature, and then to implement it. It is not an exercise where it's a legislative exercise which translates an in-house exercise of collecting data into legislation to educate and inform yourself. There is no procedure under any statute or under any common law that an exercise to collect data for the demographic profile of your own state itself requires natural justice or hearing or inviting objections to decide the validity of the data you collected. That is the first answer. This is not an exercise where when I collect data, indeed it is not only an exercise that is not required, it is an exercise that can't be done because you are doing an intensive exercise which is to collect data to inform yourself to take policy decisions which are rational and reasonable. There is no question of individually hearing all these people.
There are judgments which have referred to this exercise of publication, inviting of objections and then acting upon it.
No, to that extent, whereas we have given those notices when we went to the survey. I just read to your lordship that can you take volume 2? Volume 2 has that part where we have gone and informed people, but it is not the kind of exercise which your lordship has for an administrative decision making. It cannot be, if I have to survey 97% of the population, there is no question of inviting objections. The very nature of the exercise is different. Give me that page which showed me. Just stop. If your lordship sees that report which I showed, brothers, it has, to the extent it has to
That
involve
was
people.
for
It has,
collection of data.
yes, that's all. And the collection of data cannot have any natural justice, the quasi-judicial says. Come to Malas, page 140. To the extent it requires a reasonable, informed, rational thing, it is there. It is very specifically written there. Come to 139, Malas. Volume
Yes.
2, 139, relevant part at 141. Questions are made at 141. Then methodology means you create households and then enumerators and then supervisors for enumerators. Then you do house listing.
Yes, yes.
And then your lordship sees that page 140, last para, widespread consultations were held with all stakeholders. Their input suggestions were taken into account. There is no other form of quasi-judicial process required for this. I'm saying it's per se not required. And this can't be a ground to set aside or stay something.
Very good.
Second answer, that you do not have a individuation district-wise, as my Lord the Chief Justice rightly says, for the BC population. Well, that is absolutely true. No survey is applied in a state by applying a reservation of X% in district A and Y% in district B. It never can be, it never is. You have to live, because then there is no reason why to say that once you go to a district, you can also say that why don't you have a differentiation of individuation of taluka-wise, region-wise, colony-wise. These are always averages. It is always an average. It's an idea that the total population of a state is broadly X, Y, and Z. And we must mirror that X, Y, and Z in our policy making and our targeted incentives. If your lordship were to apply the test that ultimately the level below the state is district, then the level below the district is taluka, the level below the taluka is a block. There are wide variations. You will never be able to implement because you are doing a broad-based thing. And here, the pluses cancel the minuses. It's the average which works. That's the only practical way for every survey. And any survey, well, no other survey has ever been struck down on the grounds that you do not do an individuation of district-wise. That is number 2. These are grounds which are, have to be 2 plus 2 is 5, so perverse, unreasonable, and ad hoc that your lordship can state. Then, the third point, Gowlie's case, come to para 13. If your lordship were reading, wherever your lordship were reading it, come to para 13, SCC page 85. On the face of it, Gowlie is in my favor because it allows me, so long as I follow the procedure of Gowlie. I'm sorry, before that I must say one thing, my apologies. Gowlie's 3 learned judges. So there are 2 submissions. First submission is, please don't read Gowlie as going over and beyond and in addition to the boundaries of either Indira Sani or Janit Abhiyan. Indira was 9, Janit Abhiyan was 5 judges. So
But
am I not putting
Gowlie judgment also considered Indira Sani.
No, they did, Malad. I'm coming to the actual. They had to, Malad, because Indira Sani is binding everywhere. Now,
yes.
My point, I have 3 answers to Gowlie, Malad. Gowlie, answer number 1. Gowlie can only be an implementation of Indira Sani and Janit. It cannot be laying down new law beyond and higher than or different from these 2 judgments. One is a 9 judge, one is a constitution bench. So please read it harmoniously. Number 2, if you read Gowlie harmoniously, then there cannot be a bar in panchayat elections. Because Indira Sani says there cannot be a bar, Janit says there cannot be a bar, Justice Bhatt and Justice Sawant quoted, which I read to say there can't be a bar, absolute bar. Whether it is valid in a particular case, yes, but there's no bar. Now, Gowlie says, now the third point of Gowlie, that you cannot have it unless you do the 3 conditions. To put it in a reverse way, Gowlie is saying you can do it, provided you follow 3. I hope I'm clear, Malus.
Yes.
Now, what are those three conditions? That's exactly what I've done. In Gowli, it was not done. Gowli says you can do it. You can reserve beyond 50 provided you do these three. Be that as it may, it is indisputable that the triple test conditions required to be complied with by the state before reserving seats has not been done so far. That was the problem. Now, what was that? One, to set up a dedicated commission to conduct contemporaneous rigorous empirical inquiry into the nature and implication of the backwardness of social bodies. I hope my Lord is clear on this.
Yes.
That is the fatal flaw in Gowli, not in my case. Number two, to specify the proportion of reservation required to be provisioned local body-wise in the light of the recommendation of the Commission so as not to fall foul of the overbreadth. I have not two, but I have got three mullahs. The original data collection, the one-man commission, and the expert group, headed by a Supreme Court retired judge. Third, and one of that committee, and I'm not talking of Supreme Court judge, but I'm talking of real, genuine experts, worldwide known, Piketty, John Raj, Nikhil Dey, very well-known, eminent people. In any case, such reservation shall not exceed aggregate of 50% reserved in favor of STs taken together. In a given local body, the space for providing such reservation may be available. Now, Malas, this means, can it mean that your lordship is a bar on 50% above? Then there is no Indra Sahni and Janit. I hope I'm clear, Malas. Gowli cannot be meant to say that if you comply with the first two, you still have to be within 50.
But we can't interpret it.
But your lordships can interpret it harmoniously with Indra Sahni and with Janit.
This
Your lordship is to interpret it harmoniously with Indra Sahni, which I have read, with Janit, which I have read. Otherwise, it would mean that after Gowli, there is an absolute restriction permanently. You can't exceed 50%. Just see the last sentence, brothers. See, what was the purpose of Gowli? See the last four lines. Admittedly, the first step of establishing dedicated commission to undertake itself remains a mirage. I'm very important, my lord's query. My lord's read that last part.
Yes.
Admittedly, the first step of establishing a dedicated commission to undertake a rigorous empirical inquiry itself remains a mirage. To put it differently, it will not be open to the respondent to justify the reservations for OBCs without fulfilling the triple test. The triple test is simple. A, collect data. B, have an expert commission. C, normally stick to 50%, but demonstrate by reference to 1 and 2 that you need to exceed 50%. Otherwise, it will make a mockery of the entire law. Your lordship will not read something rigidly in a manner as to be inflexible. And this is matter of and last, I'm sorry.
Yes.
Last point on Gowli is this the kind of clear 2 plus 2 error into 5 which will justify on the threshold without pleading the final hearing a stake? This is a matter of argument and interpretation at the highest. At the highest, your lordship needs much more than that after all the exercises done by a unanimous state government across the political spectrum in legislature and executive. Your lordship has the power of quashing it. Of course, your lordship does. That is very different from saying that this is so egregious, so blatant, so one-sided, so clearly ex facie 2 plus 2 is written as 5 or 4.5 that your lordship should be able to state. Those are my submissions. I'm extremely grateful.
Yes.
I'm extremely grateful. The election schedule has been declared, I'm told, on 29th of September. That's the last point. I'll take a minute on. That paper will be handed over by Mr. Siddhi in volume 4. Please keep the page. Go to volume 4. Which page? Well, sir, that may be a separate piece of paper otherwise. The schedule is on 29th of September. That's the last reason I'm saying your lordship does not normally interdict a schedule. It's an all-state election process. Again, nobody is saying that your lordship doesn't have the power to touch it. But Malas, your lordships will require something very special and very grave. As I said, patent illegality on the face of it. 2 plus 2, I gave the example. Otherwise, your lordship does not interfere with the election schedule notified on 29th of September. That schedule has been handed over, I hope, by Mr. Six. Mr.
Yes.
Siddhi. That's the last point. I'm very deeply obliged. There are any number of judgments, your lordship. No state of Goa may be handed over. You can't interfere once Malas.
Where is the notification of this schedule of elections?
This one, Malas, 29th September, which is handed over, I think. Subject to correction by the AG's office, Malas. That is the one I have got. 29th of September. It says, annexure to notification dated 29th September. The actual notification may be handed over by my learned friend there. This is actually only the annexure. My lord, this is right. This is only the schedule.
Item number 24. Well, in item number 24, we have challenged the notification and that schedule.
That's all right. I'm not saying.
There's no gazette. The
gazette.
law requires it to be in a gazetted form, notification. This is just a schedule.
And Malas, it's well known, I don't need to cite case law. State of Goa and many other judgments open it. 2021 8 SCC 401. 2021 8 SCC 401. 3 learned judges speaking to Justice Nariman clearly say that a lordship will not interfere once this process is notified. The relevant para is 68 and the sub para 68.1 onwards in that para. 68. And this is related to municipal elections. I'm deeply obliged.
Hey,
Learned AG, is it notified this schedule?
Should be notified, my lord. I bring it to your lordship. Notified. May I have it tomorrow, my lord? I will.
Okay. Give it a copy. Give a copy to us.
I think it's not there. My lord, I will produce tomorrow, my lord. I think for it is gazetted because that's what I have it, but I found out, my lord, that the gazetting is also there. Gazetting is also there of that, my lord, of that notification. Gazetting is there also. Gazetting is there. Yes.
I am appearing for the state. I am instructed to appear for the state. May I make my submissions? Just 10 minutes I'll take that, not take much.
It is not yet over. Burma is continue tomorrow.
So this is the notification. And secondly, after that, that 27th March 2025 bill passed by the Legislative Assembly sent to the governor. Thereafter, the plea is being taken that it's a deemed consent. Whether that has been notified as a law, the
I'll find out about that. That I don't have.
nobody knows about it as
How is this a notification?
no, we'll conclude. We have already concluded. No more arguments on interim prayer.
I'll just take 10 minutes.
In that case, my lord,
I'll not repeat. I adopt the arguments of Singhvi. I'm also appearing for the state.
Sorry, one day. This is not. This is only for one district too. And he's giving for each state, each district separate istara.
As it కాదు
21 6 SCC 73
198 క్లియర్ ఉంది బడ్జెట్ పబ్లిష్ చేయాలి సారీ విడ్రా చేసుకుంటున్నా వాడు.
That is the value. Correct. I want it.
Okay, Reservation 6 SCC.
So, Learned AG, apart from Mr. Singhvi, you are representing the state. Other councils are also.
Yes,
No,
I'm
and my lord, Mr. Verma is there, my lord. Three of us are appearing for the state.
appearing for the state.
Yes, yes, please.
My lord, we'll
Please
make
make it short because we have.
My lord, I think, my lord, we'll have, it should be appropriate, my lord, if your lordship should continue for tomorrow because other friends are also there. My lord, I might take 10 to 15 minutes. My lord, the state need to be represented by the state, by the office of the state.
But there will be no end to it. We have heard the whole day.
No, my lord, your lordship, not that, my lord.
It's not the final hearing.
I'm counting heads, my lord. Your lordship, please hear 2 or 3 councils on the other side. My lord, it's the state which is important. The state needs to be heard by more than those people also. Because, my lord, what they want to do is they want to put a spoke in the election. My lord, we have to clarify to your lordship that that spoke which they are trying to put is not correct.
We have no objection, my lord, as long as the state doesn't take further steps on this issue. The state needs to be heard. That's a fair statement by the learned AG.
About today and tomorrow, there can't be any other.
That's what exactly. That's what the learned AG.
Notification is already issued.
It is not issued. Sorry,
Such a
it's
statement
not a
was made
notification.
first time when the matter had come up.
If
My lord, apologize.
if that's not the way
Apologize.
proceedings are. Making a point, it is up for us to appreciate and do further hearing or not. Let him say whatever he is saying.
So tomorrow, my lord. Because, my lord, that's the notification. If your lordship will please to see insofar as the notification is concerned.
Lord, I would like to add only one sentence. First time when the matter came
No,
up.
you don't add now.
No, learned AG. No, learned AG has said. Learned AG is,
please,
no, learned AG assured nothing will happen till today. But much water has flown up till today.
No, I did not say.
But he did assure. He did make an assurance.
So we keep it at 2:15 tomorrow, with the understanding that you and Mr. Ravi Verma
Mr. Verma.
would be arguing on behalf of the state, not repeating the argument what already said. And
Not a word will be repeated. I'll simply adopt Dr. Singh's argument.
and then we'll see some reply from the petitioners if at all.
Where the petitioners are not being infringed a single fundamental right.
How can you say that?
And they have been filed the frivolous petition. We will demonstrate along with the quantum of law of unapex court before your lordship.
Complete petitioners will hear at the final hearing stage.
No, after completion of the state, my lord, after completion of the state.
My lord, I hope
Because single petition would not be sustainable
respondents,
before your lordships.
Complete petitioners, complete respondents will hear at the final hearing stage. We had
No.
good consumption of
Lordships,
submissions
one
from
request, my lord. My lord,
My
one
humble
request.
suggestion-
state side also.
The nomination process starts, my lord.
This should not be an excuse to